Hello, everyone. Happy Tuesday. Welcome to Startups in the Law. If you haven't come to this event before, we host it monthly. Kyle Kertz is here to tell you all about starting your startup and the law. So he hosts these once a month. If you enjoy this, definitely recommend it to a friend. And thanks for coming. With that, I'll bring up Kyle.
Thank you, Alex. I really appreciate the introduction. As Alex said, we host this webinar the first Tuesday of every single month. Sometimes we have to reschedule it due to conflicts, but as far as this goes, we will be here same time, 10 a.m., first Tuesday of every month. As far as this webinar goes, this is an educational webinar. I want to start off by saying that this is not a sales pitch for our law firm. This is really more a matter of providing you with the information that you need to be able to start your business the right way the first time. That said, throughout this webinar, if you have any questions, do feel free to use the comments box. I want to make sure that you have the ability to ask questions while we're going through this in real time. I'll try to be as responsive as possible and actually catch these while we're going through this. And so I'll be reading them if you're submitting them. Without further ado, we'll go ahead and get started. So just to give you a little bit of an idea, we have two offices. One is in OKC, one is in Dallas, Texas. I'm based in Dallas. My name is Kyle Kertz. And then Matt Jones is based in Oklahoma City. He controls basically all of the startup stuff up in Oklahoma. You know, whether it be OKC, Tulsa, or some of the stuff in Texas. He's helping out with that. As far as I'm concerned, I deal with a lot of startup stuff based in Texas. As far as questions go, if we're addressing something that is not being covered, today, or if you have a question about something that is not being covered today, do feel free to email me at kyle@joneskertz.com. Or if you want me to address something that's not being covered today and you just want me to address it very briefly up front, do feel free to drop it in the comments box. I want to make sure that I get to your questions, and I want to make sure that we answer, the stuff that you came here to learn. Okay. This will be different webinar every single time. I do try to make it interactive, and I do try to make it a little bit, or I do try to go pretty in depth on some of this stuff. So, do keep in mind, that we are here to answer these questions. Okay. The mission here, I believe that, better education leads to a better legal foundation, which leads to more successful startups. among the startups that we help and among the businesses that we have personally started as a law firm, we can say that 99% of our clients are still around. Now, why is that? It really has to do with the fact that, we are in the orbit of these people who are running these businesses, who are growing them, who are literally hiring employees in some cases, 1 a week, 2 a week, because they're growing so rapidly. And we're helping make sure that their business is protected along the way. That said, I'm not sitting here overloading, people while they're trying to, build their business. We're basically, whenever something comes up, we teach these people and we coach them on how to identify the need, for an attorney. And while that's not exclusively the purpose of this webinar, part of what I'm trying to teach you is when to realize you're out of your element and should seek someone else for help. Okay. It doesn't need to be us. You just need to know that you need a startup lawyer or a business lawyer for that, so that you can go get that work done and pay somebody else to do it professionally and make it right the first time. So that said, topics covered today, we're going to go over really quick, a legal news update or startup news update. And then we're going to go over pretty in depth, choosing the state to start your business. And I'm going to go over the major ones that are popular today and go over why you might start a business in that state versus this state and what the different considerations are. And that has been a particular topic, for startups lately. Where is the best state to start my business? Where is the best state to start my tech startup? We're going to answer that today. And then, last but not least, converting from one entity type to another. I get this question practically every single week. Should I convert my LLC to a corporation? Or the other question should be, should I start just as an LLC and then convert later, or should I just start as a corporation now? I'm going to answer some of those questions in a way that will give you a little bit of direction so that you are not just sitting there going, oh gosh, just throwing your hands in the air and using LegalZoom to start the business and realizing, oh gosh, well, now I started a business that I don't really need, and you basically have a throwaway LLC or you have to pay somebody to do an expensive conversion. We can solve a lot of problems on the front end so long as we ask you questions. But I'm going to give you, most of the information you would probably need to make that decision for yourself. That said, legal disclaimer. This stuff is not legal advice. Unless you're a lawyer and you do this for a living, I don't really recommend that you go out starting businesses or start your own business. I've seen other people try. I've seen them do it very poorly. I've seen people who, are not lawyers, start a business and, draft an agreement, fairly well. The only problem with that is, you're not an attorney, and, if you have, other people who are invested in your company and other people who have, or if you have employees, you're really doing them a disservice if you're not seeking professional help for contracts, if you're not seeking professional help or guidance for certain things like investment and capital raising. Just keep in mind that all we really want is for you to protect your business and protect yourself from accusations of fraud and other liability, right? So, remember, you're not a lawyer unless you are one, and even if you are one, unless you're a startup lawyer or a business lawyer, seek outside help for this sort of thing. All right, moving on. So just so y'all are aware, Dallas Startup Week is this week. It is at Southern Methodist University. It is still going on. It is going on right now, and it will be going on until Thursday. There is still some availability, and you can go and get a free ticket off of Dallas Startup Week. The dec.co is the website for that. As far as signing up for some of this stuff, they've got a whole host of different events. They've got networking events. They've got tons of different stuff that you can do and learn. And this is a great place to meet people. It's a great place to meet investors. It's a great place to meet other people who are aligned with the startup community and who are actively, growing their own startups. So I would encourage you, if you're looking to get into this sort of thing, or you're looking to meet people, or if you're interested in starting a tech business or starting any kind of business really, that you should go and hang out there and just, absorb and be a sponge and meet these people and network, because it is a great event to go to. I'll be going there tonight at 6 p.m. for their networking event. to go have a drink and hang out with some of the other people there. Aside from that, let's talk about choosing your startup. This is basically going to be a broad overview of what you need to know about this. Like I said, I'm going to compare, different states. I'm going to tell you some things that are probably, other lawyers may disagree with. The truth is, I don't really care. I do a lot of this stuff every single day and help people make these decisions every single day. And so I'm going to give you actual instances of how we coached people and what we said to them in order for them to come to a decision on which kind of business to start in what state. Okay. So basically here, major bullet points to consider whenever you're going through, this thought process of picking a state to organize or incorporate your business in. Obviously one of the first considerations is going to be what kind of entity, LLC or corporation. Every state in the United States allows you to set up an LLC or a corporation. Like you can go anywhere and get that set up. That said, not all LLCs or corporations are made the same. The reason has to do with the fact that there are differences in state law. In every single state, there are differences in state statutes as well as state case law, otherwise known as the common law, which governs, the little gaps in the statutes, right? Or the interpretation of statutes, right? So as far as we are concerned, there are certain states that have, in our opinion, superior case law or case law that better protects technology startups, that better protects people when they're engaging in securities transactions, that better protects people when they're engaging in activity that governs material decisions of their business, such as taking out a large loan, such as converting the entity, such as doing an investment deal, things like that. Other major considerations, though, obviously income taxes. One of the major draws for starting a business in Texas is obviously the fact that you as an individual, unless you make more than $1.18 million a year, will not pay income taxes. And even if you do make more than around 1.2 million a year, you're probably not going to be making the tax rate is like 3.75%. It's really low. It's really almost so insignificant that the state really isn't earning any money off of you at that point. That said, franchise taxes are another major concern. Some states make you pay an annual minimum franchise tax or an annual set fee just to renew. The state of Texas, however, does not. And I'll get into that in here in a little bit when I do a comparison between Texas and Delaware, because that's the most common comparison that we do. Aside from that, ease of filing a certificate of formation, articles of organization, and incorporation, that's kind of lower on the list, in my opinion, as far as the considerations go. You can use LegalZoom and you can use BIS filings. And you can use all these other sorts of, like Stripe Atlas or Gus Launch or, other services that might have been created for such a thing. And really, whatever complexity there is to filing to start a business, those businesses can help you, sort of get around those complexities because they're just going to do it for you. It's what you're paying them for. Same thing if you pay a lawyer to do this. We already know all of the complexities and we're trained on those things, very early on in our careers. And so it's just a matter of, have we done that before in that state? Yes. We just go file it, right? Ease of filing annual reports, that can be a little more difficult in some states than others. Some states, the Secretary of State manages all that. Some states, they call it something different. They'll call it a comptroller's office, which manages, the annual reports, or they'll call it the tax commission, which requires you to file the annual report, or they'll make you file two reports, one that's a tax commission report and one that's, an annual Secretary of State, public information report. There is a little bit of nuance to that and a little bit of difference. I'll go into it a little bit further here in a little bit, but the other thing to keep in mind is whenever you're starting a business, registered agent fees can become, somewhat of an expense that just recurs and provides very little, value. Registered agents, by the way, are the individuals who are allowed by law and designated under, the certificate of formation, the articles of organization or incorporation to receive what's known as service of process. Basically, if you get subpoenaed for something as a business, if you get sued as a business, whoever's the designated registered agent is going to receive a certified copy of whatever lawsuit or subpoena or anything like that has been drawn up, right? That said, if you are, let's say you are headquartered in Texas and you have to go and you have a Delaware corporation or a Delaware LLC, then technically you need to foreign register the business in Texas. And so when you do that, by the way, you can decide whether to pay somebody else or you can decide to do it yourself. The only problem is in the state of Texas, the company itself cannot be its own registered agent. Whereas in other states like Oklahoma, it can be its own registered agent. So there's a little bit of nuance there, but the truth is, you do need to look at the fees. Really, $50 in my opinion, $75, $100 is really the max that you really want to pay somebody else to do registered agent work. Any more than that, and you're really paying far too much for it. I believe if you go to LegalZoom's website or use their registered agent service, that they're charging somewhere in the range of like $200 to $400 a year for it. I will tell you that's a little bit ridiculous. It provides very little value, like over the long run, and is really a nice thing to have. To give you an idea, our law firm serves as a registered agent, but the difference in value that we provide is that we are a first line of defense. So if I receive, as the lawyer, service a process for a lawsuit, then I know what the deadlines are in order to respond to that lawsuit. If a client of mine receives a subpoena, I know what the deadlines are and can read it for them and interpret it for them and basically say, here is the document that we were given. Here's what you need to go do about it. In some cases, I can, provide further legal services to them in order to help them with that. And some clients like that. But the truth is, as far as the most important consideration goes, the most important consideration should really be, how well the state law protects you as a business owner as well as your business. There is some, there is some significant difference in how well some states protect protect business owners. There is a little bit of difference in, single member versus multi-member, but I don't want to confuse a lot of people because there is some, there are some, rumors, and I do want to address some of those rumors when we talk about, single member versus multi-member, that go around non-lawyers and go around, other professionals such as accountants, where they sit there and think you must have, a multi-member, LLC in order to fully protect yourself, right? I'm going to explain why that's not really the case. Okay. Aside from that, before we get started and I go really in depth on this, does anyone have any questions or have anything that they would like to, for me to call out or answer as a part of this? Okay, if not, I'm moving on. If you do, just drop it in that comment. So aside from this, choosing Texas versus Delaware to start an LLC, as Texas, as Texas attorneys, this is probably the question that we get most often, when it comes to starting, an LLC or a corporation. Should I choose Delaware or should I choose Texas? Some people, if you've been to college, you've probably heard that, Delaware corporations, Delaware LLCs. If you've been to law school, you've probably heard about this, that like Delaware entities, are generally have this air of superiority about them. They're generally viewed as superior and generally viewed as providing greater protection to founders, to investors, to the people that run companies as officers who may not own equity, et cetera. And so here's a little bit of a comparison. So from a cost perspective, to get these things set up, it's kind of the same. I will tell you that it costs kind of a lot to start up an LLC or a corporation in the state of Texas. The costs probably have to do, the reason why it's higher than a lot of other states. So for comparison's sake, in Oklahoma, it costs $100 to start an LLC. It probably costs only $300 because the state government of Texas does not collect an annual fee usually for filing annual reports or anything like that. And then, as far as the, the cost goes, like they don't charge state income tax, so they have to make their money, some other way. And, as far as it goes, I think 300 is an okay number. I do think it's kind of high. I do think it serves as a barrier to entry for some people, because $300 is a lot of money for individuals, especially if you're trying to start a business and you really don't have any spare cash. $300 can really, take it out of somebody's, startup, basically seed money that they're using. As far as the cost to file in Delaware, it's fairly similar, but the reason why I say it's around 100 to 400 is because it really depends on whether you're expediting the filing or whether or not, and there's usually a bit of demand flux. Quite frankly, I've never seen any two, documents that we have filed that were expedited with the Secretary of State for Delaware that came out to the same exact number. They have some sort of weird system that is set up so that it actually gauges the supply of time, I guess, that is available for the Secretary of State's employees to be able to process requests and applications for formations, versus the demand for those formations or articles of organization. The ease of filing a certificate, I say it's high as a lawyer. I think it's pretty easy in the state of Oklahoma. It's so easy, in fact, that most people will actually ask you, why do I even need a lawyer in Oklahoma to file an LLC? It is actually stupid easy to do that. In Texas, though, it's a little bit more difficult for the normal person if you're doing it for the first time, because you have to get, you either have to fax it in or mail it in, or you have to get, an SOS, a Secretary of State direct account, which most people, you're going to be using software that looks very similar to, like 1999 furniture store level software. It looks like it's still running on Windows 98 or using HTML in some cases. But as far as the Delaware filing website, it's actually fairly easy to file in Delaware. The only problem is they provide an upload system instead of providing, just a web form. And so in Delaware, unless you can find a different document online, unless you can find a document online or have a lawyer or somebody else draft one up for you, you really have to go, submit the document to start an LLC or to start articles of incorporation, which is not as straightforward as you would think it is as far as drafting that stuff, because of the things that need to go into that document, just at the very beginning of the formation of those companies. Franchise taxes. You do not pay franchise taxes in the state of Texas unless you make more than $1.18 million a year, which is a really high threshold, obviously. And to be honest with you, that is one of the greatest benefits of operating in Texas. Most people will never have to pay a tax to the state of Texas the entirety of the time that they operate their business. It's a pretty good benefit. The only downside is, in some cases it costs a little bit more to live in Texas. In some cases it costs a little bit. It costs a little bit more to, I would say, prices for services in Texas can be higher than prices for services in other states. So whatever savings you might get from not paying franchise taxes might actually, be negated by the overall market rates for other things you're doing and other expenses you're running. Franchise taxes in Delaware, minimum 300 for LLCs in Delaware. It's 400 for corporations minimum. And it's important. I will tell you why you probably want to seek the advice of a lawyer or use one of those, online systems to help you set up your corporation. If you set up a no par value corporation, you could potentially owe the state of Delaware hundreds of thousands of dollars a year. There's virtually no reason to set up a corporation in the state of Delaware that does not have par value. Okay. As far as, and par value is basically, the definition of par value is basically, what is the minimum redeemable amount of, money that this stock can be redeemed for? And it's basically 0.00001, something, it's basically, a thousandth of a penny almost. And so, but the problem is, in Delaware, I will tell you, Delaware, while the level of protection you get in Texas from an entity level, under the statute as well as under the case law, from a liability standpoint. So let's say something goes wrong, your LLC gets sued. You didn't really do anything wrong. Maybe it was negligence, but it wasn't fraud. It wasn't willful misconduct. It wasn't anything like that, but it was negligence on behalf of the company or something like that. The business will be protected and insulate the individuals really well. That's just the way these LLCs really work. That said, in certain cases, if you are committing fraud, securities fraud, especially, there is no zone of protection that a business provides you in that situation. Aside from that, though, like when it comes to Delaware, from a corporate standpoint, from an LLC standpoint, Delaware does a really great job of protecting people. The case law, the Delaware is what we call a very contractarian state. If there is a contract that governs the agreement between the two parties, and the issue at fact is breach of contract, or some sort of misrepresentation of the contract or something like that, and the one party sues another, in general, the contract is construed the way it reads. They don't tend to rely on a lot of outside evidence as far as the case law goes in the state of Delaware. That said, you do have to make sure that the contract is drafted well, and you do have to check the law rather frequently, because they have a lot of cases that come through and they modify the law pretty regularly. And so I will tell you, in general, why we start a lot of businesses in Delaware and why people prefer Delaware and why, investment funds prefer Delaware. Well, it has to do with the fact that it does a really good job of protecting the money of the company, the underlying assets of the company, from third-party claims. It does a really good job of protecting investors in certain cases. It does a really good job of protecting people in really high-dollar, complex transactions. You'll see that practically every single major private equity case that comes down in the state of Delaware, like a lot of these things will involve hundreds of millions, if not billions of dollars. In some cases, the lawyers that have drafted those agreements are so smart that they've literally interpreted the law to see where it's going and drafted the contract for where they think the next case will land. And that's extremely important. It's actually, fairly innovative as far as, the judgments that are coming down as far as the case law goes in the state of Delaware are pretty much innovating the law on a regular basis and updating it on a regular basis. And, for better or for worse, the truth is, it's changing so constantly. In my opinion, it changes far more than it does in Texas. That said, that's kind of a downside too. The problem is, with some things that you might do in the state of Texas, if you're getting legal advice from somebody who's not keeping up to date on judgments, or is not keeping up to date on Supreme Court or Court of Appeals cases, then in some cases that person may not be drafting the contract the way it should be. But that's with any state, that's with any practice. It's up to the attorney who's doing that, who's drafting the contract, to ensure that they have adhered to the law as it reads today. That said, in both states, the registered agent thing, you got to have a registered agent in both states. The only problem is if you have a Delaware LLC and you go register it in any other state, most other states will require you to have an in-state registered agent. Meaning, if you go register in Oklahoma or Texas, you're going to have a registered agent in those states. And so you'll either have to pay somebody to do that, or it'll have to be you. And if you don't live there, it can't be you unless you go buy a mailbox or pay for some other service to have your mail sent out, or somebody else to be your registered agent and have an address. So aside from that, we do have a question, what are my fees compared to LegalZoom, et cetera, for registered agent work? I charge $50 annually for it, though I take it via credit card, up front before we become the registered agent, and I set up auto pay. And it basically charges automatically to the same credit card every single year. The reason we do that has to do with, it's just simpler that way. Also, LegalZoom, like when I get mail, like instead of just sending it to people, I also, provide them with instructions on what the mail they're receiving means. That's the downside with LegalZoom and these other entities. You're not getting a human being who's explaining anything to you or the significance of a document whenever they send it to you, if they're being your registered agent. And, like they'll, I will tell you as a registered agent, I do also, filter the mail so that you're not receiving anything you shouldn't be. So, unless you wanted to be sent, credit card, applications or something like that, we don't send those to you. We filter out all the spam and junk mail. And then, there are, services, or not services, I should say, there are scam companies that will send you, mail that looks very, very similar to Secretary of State or comptroller mail or tax commission mail. And, I usually catch it, and then, I pitch it. I literally just throw it away or shred it. And I've had people come to me and they'll send me a screenshot of it. They'll text it to me or they'll email it to me and say, what is this? Do I need to fill this out? I thought you already formed my business. I did. That's a piece of scam mail. Throw it away, is what I tell those people. And the problem is some of those people would never know. It's almost preying on the elderly. It's preying on people who are just ignorant. So that's, the difference in the service, I would say. That said, I wouldn't say it's a high value service, and we don't charge a lot for it, annually. So it's not like we're acting like it's a super high value service either. Aside from the fact that if I do actually, get a lawsuit that's sent your way and I intercept it basically because it's coming to me as the registered agent, you're in a way better position to respond to it if it comes to me first. Aside from that, what about other states? Because, I don't want this to just be about Texas and Delaware, right? I have actually formed a California LLC before, and I will tell you it's a freaking nightmare. California LLCs and California corporations are extremely expensive to start and extremely expensive to operate. The only reason we did it, and I did it maybe 3 or 4 years ago. The only reason we did it is because the person had purchased property in the state of California and wanted to have that property held in a California LLC or have it held in an LLC. And we went through the analysis and said, do we form a Texas LLC and domesticate it in California, or do we just, form a California LLC? We decided just to form a California LLC because when it comes to holding real estate, it doesn't really make any sense to have the LLC formed in any other state. Unless, of course, you just have money and have the ability to just spend an additional amount of money to go register that business, register your Texas LLC or wherever it started in other states so that you can, use the LLC for that purpose. Basically, if you're putting the LLC name on a deed, you're considered operating in the state that you are in, the state where the property is in. So, you do have to register at that point. You will have to pay the fee to do that. If you're the type of person who hasn't done that, I would recommend that you either figure that out or hire someone like me to figure that out, only because it really does. Usually it's a one-time fee. Usually you don't have to do anything else. But in general, I will tell you that, it does help you in the event you have to respond to any sort of claim. For example, in the state of Texas, if you're operating a Delaware corporation or LLC in Texas, but you haven't registered it in Texas and you get sued, technically the law says that before you can even respond to the lawsuit, you have to register the business in Texas. And obviously that's problematic. If the timing of that lawsuit or when you received the document is, if the timing of that is really close to when you're filing or your response. Aside from that, though, the major disadvantages come with the annual fees. The annual fees are killer, man. The $800 annual fee before they even take into account the calculation of any taxes in addition to that you might owe. That's just obviously a glaring problem for these entities. Basically, they're basically telling a lot of people that you effectively have to be middle class in order to operate an LLC in the state of California, which I think goes quite against what California claims to be about as far as helping people, as far as equality goes. They've really created a system that is more bourgeoisie. Like or board. I don't know how to even pronounce that word, but I know what it means. As far as they're basically creating a class system, like where poor people will never own an LLC, whereas in Texas, poor people could easily own an LLC. But they say, the minimum annual fee waived for first year, not for second. The expectation is that you would make money. The problem is that it doesn't cover any of the fees that it would take to terminate that thing in the second year. So effectively, you go for free from the first to the second year. If that entity doesn't owe any money, you're still going to owe the $800 the next year. So, in my opinion, the annual fee is just a deal killer for me. The cost to file, $215. Like I know that a lot of people may not care about this, but it's just, I've got to throw out the cost for these things. Taxes on income can be enormous. I once made $12,000 in California for a summer's worth of work. And they withheld like $5,000 or $6,000 in taxes from me just for the money I was making there based on the salary that I was prorated to have made. And it was quite ridiculous, actually. It was more money at the time, I was like 22 years old, 23. It was more money than I'd ever made in my life. But it was also, like once I got the refund check from the state of California, I realized just how terrible it was. I didn't realize how much money they were taking. It was a lot. As far as, and then, the other point, it really only makes sense, in my opinion. So if you live and operate a business in California, otherwise, form the business elsewhere. If you're forming a corporation or an LLC, and you are not in the state of California, there is no reason to form a California entity. Okay. That said, if you are in San Francisco, if you are in LA, if you are in, any other part of California, operating a tech company, corporation, LLC, whatever it is, then in that situation, it makes sense, for you to foreign register the entity in California. You really should do that, because the truth is, if they find out that you're not registered and you're not paying taxes to the state of California, you're going to owe back taxes, and you're going to owe the penalties on that as well. So just keep in mind that you have a requirement to foreign register, if you're operating a business in any state other than the business in which you're incorporated or organized. Do we have any questions so far? This is new, by the way. So I'm about to talk about Nevada and Wyoming. Nevada and Wyoming are trending right now as far as the hot new place to start a startup. I literally this morning was on a phone call that lasted for an hour, and the documents that we were reviewing were a royalty-based promissory note. So basically a royalty-based loan for this tech company. And it was a very reasonable document. And then I realized that the business was based in Nevada. It was a Nevada limited partnership. I'm sure they have a Nevada LLC that's managing the investments in the company itself. And so I thought it would be interesting to talk about this. Nevada is really making an effort to compete with Delaware to be known as, quote unquote, the best place for business. And by best place for business, we mean, basically, an income tax haven. They're not really going to charge state income tax. They're going to have very low fees to operate that business. And then on top of that, they're going to do a fantastic job from both a state law perspective and a case law perspective at protecting people from liability, personally or otherwise. And so when it comes to Nevada, I will tell you, there are certain differences about Nevada that I like. But the problem is, starting Nevada LLCs, as far as pitching it to people, I as a lawyer can't really pitch that to people, only because we're Texas attorneys also, but also there is, as far as I'm concerned, it's hard enough to keep up to date with, Texas and Delaware. Keeping up to date with Nevada would be really difficult because their laws are changing and are actually have been changed so recently that it would be difficult to see how the case law is adjusting to the change in statutes. That said, there are some recent changes that we are aware of that suggest that Nevada LLCs, and specifically actually Nevada series LLCs, are actually, superior in terms of liability protection to Texas LLCs and to Delaware LLCs. So keep in mind here, like when we're looking at this, I can sit here and throw up the filing fees, $75 plus $200 for a state business license, plus $150 for the initial list of managers or managing members. I'll tell you, why they don't just charge one fee for this is beyond me. There shouldn't be 3 separate fees for what is effectively just a certificate of formation. That's just, for whatever reason, they've decided to do that. The other thing here, ownership is not public record. So if anonymity is important to you, which it is important to a lot of businesses. So, take, for example, we oftentimes help doctors, purchase property such as rental property for business purposes, for investment purposes, and things like that. Doctors do not want their information to be public, especially if they make a lot of money as a doctor. The reason has to do with the fact that they're a malpractice claim target. Anybody who might want to claim malpractice against them would want to know exactly what they own, would want to know exactly how much money they have, and see, how much could I get, how much in assets do they have. So anonymity, is a great advantage to having a Delaware LLC. It's also a great advantage to having an Oklahoma LLC. There is a slight disadvantage to having a Texas LLC, actually, and it's that, with Texas LLCs, if you're member managed, you're basically disclosing who the members of the company are and who the managing members of the company are. That said, if you're manager managed, you can designate one or more managers that are not members. So technically, the membership structure, the ownership structure could be anonymous in Texas, given certain things, right? So aside from that, though, it's really up to you whether you like anonymity. I have, in some cases, actually layered entities one into another, basically a Delaware entity into a different kind of entity, effectively to create, a ghost company, like is what we call it. Basically, I've created an entity that no one will really ever be able to tell besides the IRS, who owns it, because the only person who will ever receive a disclosure of the entity's ownership structure will be the lawyers, will be the individual owners of it, will be the accountants, and the IRS. Those are the only 4 people who will ever know anything about it. And aside from potentially bankers, but bankers are usually asking who has the authority to sign, not who has not who the ownership, not who the individual owners are. Right. So, and that's one thing, Nevada provides anonymity. Like I would say, they're still asking for an initial list of managers. So I would say it's kind of pseudo anonymous if you're doing the manager structure, which, by the way, as in general, like if you're forming an LLC in the state of Texas, we recommend, or really anywhere, we recommend that you be manager managed as opposed to member managed. The reason has to do with, what we want is to create a further zone of protection around the individuals who are operating the company on a day-to-day basis. And the only real way to do that is to make it a manager-managed company. While the members may actually be the managers of it, that separation, that fine line of separation is still enough in some cases to beat back a claim that the members were actually managing this thing and thus the members are liable personally. Right. The state of Texas actually considers a member who is also a manager to be considered 2 separate people. It's as if their interest as a member would be passive. Right. And that's the goal there, and especially if you have passive ownership in your company, it really makes more sense for you to be manager managed. Annual reports and annual business license renewal fee, $150 and $200. And this is why, financially, if you're looking at the price to start as well as the price to keep it going, it's actually more expensive to form it in Nevada than it is in the state of Delaware, from what I can tell, because the ongoing expense is higher than a Delaware LLC or a Delaware corporation. That said, like I said, not saving a ton of money to go this route. it's kind of a nice to have if you want to have it, if you can afford it, right? That said, a lot of people that we deal with on a regular basis couldn't care less what it costs. They just go spend it. I don't care. It's the cost of doing business. It's the cost of making, millions of dollars a year to have that kind of protection, right? And so you get what you pay for in some cases. It just lacks a lot of popularity, I would say, by the way, too. And that's the other major drawback. Delaware is highly popular, is highly regarded as, a haven for business. Nevada is not. I personally, as somebody from Texas, don't really want to be associated with anything in Nevada aside from, going to Vegas every now and then. But aside from that, though, like having an entity in Nevada, though, it's feasible. The only thing I would say is with series LLCs, which, by the way, the difference between a regular LLC just provides a zone of protection around a business and its assets, at a basic level. A series LLC is basically a hub and spoke format. So basically, you have a parent entity, which is the initial series LLC, and then the spokes coming out from it in every direction. Series 1, Series 2, Series 3 can hold assets like real estate on an individual basis. And if you're doing everything right under the law and you're accounting for the property separately and holding it separately and doing so explicitly under the structure of the business in writing, then technically the law usually says that you can't pierce laterally, like from one series to another. So I can't, like if I have a judgment against, Series 1, which had a house as the asset because I was, the tenant and I fell down a flight of stairs that wasn't built correctly or built to code, and I sue those people for negligence or gross negligence and win. Like technically, the only claim would be against the assets of that individual series. You couldn't go and claim, the assets of the other series. And Nevada has fully embraced that concept, which is a concept that exists in about 30 to 40 other states. I'd have to look at the numbers nowadays, but I believe it's hovering somewhere around 35. The problem is in other states such as Texas or, in other states, they haven't fully embraced the concept. And I've read some, articles on it. That said, like there are some articles, especially from the American Bar Association, which is, an attorney organization, has basically recommended against series LLCs. But I say that shouldn't be the case. Series LLCs, the way the statute reads is very clear. If you operate it properly, you get that protection. And that's the way, and really that's the way I interpret that law. I would say, if I wanted to start a series LLC and, I was doing it in a certain way, I might choose a Nevada series LLC the next time because it actually does make a lot of sense. Do we have any questions about that? Just want to give a chance for everybody to catch up or ask a question if they want. Wyoming is trying to compete with Nevada and, Delaware. Wyoming is kind of a lark in that they've created basically this chancery court, which is what's called a court of equity. And basically for any breach of contract related issues, for any issues related to the interpretation of written agreements, they basically will remove those from normal trial courts and take those and exclusively hear them in the chancery court itself. Pardon me. I'm going to take a drink of water. So aside from that, though, it's pretty cheap. It's $100 to form a Wyoming LLC. And then, the annual report license tax is $60. So, initial, 100 plus 60 a year is nothing compared to the others, I will tell you. Apparently there's no state income tax as well on LLCs. We're seeing a lot of common factors here, by the way. It's very difficult in Wyoming to pierce the veil on LLCs. So there is actually a change in the statute that went through back in 2017, I believe, where the state legislature of Wyoming passed a new law that said failure to observe corporate formalities is not a reason to find an owner of an LLC liable for something just on its face, which is not the case in some other states. In California, if you fail to observe, an annual meeting, if you fail to observe, needing resolutions or written consent for something like that, for material action of the company, they could consider the LLC to have, not really even existed for purposes of finding, the managers or the members liable personally, which is a problem, right? We don't want that. And as a matter of fact, LLCs are meant to be flexible. They're not meant to be super rigid like corporations are, especially not publicly traded corporations. But yeah, in order to find someone liable and in order to pierce the veil, and by the way, piercing the veil means they are able to pierce the corporate veil, the zone of protection that is provided by an LLC or a corporation, and attack the assets of the individual members or shareholders of a business. In order to do that, something more has to occur. There has to be willful misconduct. There has to be fraud. There has to be some sort of, it has to arise to something that is greater than just negligence, or an accident happening, right? So aside from that, though, LLC members in Wyoming, very insulated from attack on personal assets. Charging orders are the common phrase. And this is what I was talking about before. There are some common rumors and what I would call urban legends going around that say, in certain states, instead of a single member, some people are saying you need to form a multi-member, manager managed or member managed LLC. That's not the case, though. Typically, if you do everything right with a single member LLC and you capitalize the LLC well enough and keep enough cash in its accounts and enough assets on the books, then that LLC should afford the members protection. It shouldn't result in what's known as a charging order, which means somebody is filing an order with the court to be able to go and attack the personal assets of the individual members of the LLC. There seems to be some rumor that single member LLCs are just not very good at protecting people, which I think is wrong. So long as you're running your business correctly, single member LLCs do a very good job at protecting you. In really any state, by the way, aside from California, I would say. California is a bit different in that they oftentimes will actually, very liberal rules on piercing. Aside from that, LLC members, Wyoming is one of only around 15 to 20 states that allows you to combine a domestic asset protection trust with an LLC. To be honest with you, domestic asset protection trusts are probably more of an estate planning concept. They're probably used a lot when people create, their own family living trust, right? And use that as a way to not just shield personal assets from outside people and creditors, but also from claims related to business entities. And in that situation, creditors cannot pursue the business assets to satisfy personal debts. Such a concept in the state of Texas does not really exist at the moment, I will tell you. And the other major benefit, like I said before, anonymity, no disclosure of membership information. That's the other major benefit here. I will tell you, I've seen, people who have formed Wyoming and Nevada LLCs. Do it if you want to, I would say, have a ball. But the reality is there's really nothing wrong with a Texas LLC and there's really nothing wrong with a Delaware LLC. And there's, for the most part in most states, nothing wrong with any LLC in most states. Florida, comes to mind. Florida has very similar rules to the state of Texas. So, you're really not looking at much of a difference, especially in terms of income tax either as well. Aside from that, though, major takeaways that I want y'all to understand here, especially tech startups, especially for, businesses that will be taking hundreds of thousands, if not millions of dollars worth of assets in exchange for equity, things like that. Figure out if anonymity of members, owners, directors is important to you. For some people it is, for people like me, it would be, I would prefer that most people would never turn up on a search result, showing that they own a particular business. unless of course that particular business, they want to be associated with it, and they publish their profile online so that they can be associated with it. The caveat here is, at the beginning of next year, there's a federal regulation that's going into effect at the start of 2022, which will require disclosure to the federal government of the beneficial ownership of the business. Number one, this is designed to reduce the amount of money laundering that is occurring in the state, to reduce the amount of money laundering that is occurring in the United States. So basically, you going back to the layering of entities that I talked about, on the new disclosure rules, if you are layering entities within each other, you will have to disclose all of the beneficial owners of every single person down the chain, which is a problem for people who do money laundering, because that's exactly, not being listed on a certificate of formation or articles of organization for a company, whether it be US or whether it be, Cayman Islands LLC or something else. It is, to them, it's pretty important that they don't ever get their name put out there, right? So aside from this, you also want to make sure, figure out how much you will spend to maintain the company's active status. Not all companies cost the same amount of money to maintain on a regular basis. And it is kind of a shocker sometimes when I send, people a notice that, hey, we got a letter from your registered agent, in Delaware. We serve as your registered agent in Texas, that, hey, you owe them, you owe the state of Delaware, $400, right? We obviously don't want you being surprised by that sort of thing. So we tell you up front, usually we send you a closing letter and it says that in that sort of thing. So aside from that, find the state that provides the most protection for the type of business you want to run. It provides the most simplicity, I would say. That's the one I forgot to add. You want simplicity out of your business. The least complicated business is the least expensive business to run, right? Usually. And what I'm talking about there is from a maintenance fee standpoint. You don't want to have to continuously maintain this thing, right? Aside from that, if you're just holding real estate, here are some recommendations. If you're just holding real estate, domestic LLCs in the state where the property resides are the best way to go. I saw I'm in a Facebook group with 15,000 other lawyers, which for the most part is a shit show. It's just an absolute dumpster fire of comments and people being mean to each other and basically calling each other stupid sometimes. As far as LLCs go for real estate, if you're buying rental property in Colorado, it makes a ton of sense to just own the rental property in a Colorado LLC. That makes a lot of logical sense. Don't start a Texas LLC, go domesticate it in Colorado. Just start a Colorado LLC. It's basically the same thing, and you'll get by, relatively cheaper, and also it'll make it easier for you to just pay taxes every single year. You won't have duplicate filings that have to be made at both the Texas level and then at the Colorado level each year. So the amount of work that goes into maintaining it is actually a lot less. That's one of the major benefits. But if you're a tech startup, and you need to raise capital, you need to raise seed money, Series A, et cetera, go to the corporation, preferably Delaware. You will experience a lot less friction. You will experience way less, way less questions about, why did you go with a Texas corporation, not a Delaware corporation? Well, I don't know. It's usually not a problem if you have a Texas corporation. Most people understand that, hey, we can protect ourselves either way. It doesn't really matter. But Delaware corporations, when it comes to VC and when it comes to tech startups, are generally considered the norm. The way I view these things, why buck the trend? Why do something weird and potentially, make it more difficult on yourself, right? And also just keep in mind, if you're starting a tech startup and you're sitting there thinking, gosh, I really need a company to do this thing, but I can't afford to pay a lawyer to do, to pay the $3,500, $4,000 that it costs to start the Delaware corporation, basically what happens is people start a Delaware LLC or a Texas LLC and then convert it later. The only problem is it costs more money to convert from an LLC to a corporation usually than it otherwise would for you to just start the corporation. And so I just tell people, why not just make it easier on yourself and just start the corporation the way it's going to need to be started. It's shutting down a corporation, by the way, is easy. Like it takes like a week maximum to draft any of the documents. I mean, really, it should only take 2 days if you have experience doing it. Aside from that, starting a series LLC for your business, consider starting a series LLC in the state in which you'll operate. You really don't want to create any sort of difference in law issues with your series LLC. To keep in mind, by the way, if I start, a Nevada LLC that has a lot of protection in Nevada, and then I go operate it exclusively in the state of Texas, they're going to treat that Nevada LLC basically like if you get sued in Texas, or if that LLC gets sued in Texas, the courts in the state of Texas will treat it basically the same as if it were a Texas LLC. So in some cases, the protection afforded by different types of entities can be a bit illusory, right? We want the state's law that protects it, really well to govern most contracts that are being signed, if not all contracts that are being signed. That says certain contracts can't be done that way. For example, employment agreements. You really need to have employment agreements. You really need to have employment agreements governed by the state law in which the employee, resides or which the employer resides. Usually we say it's the employee. Other types of companies can typically go with a regular domestic LLCs to start and convert later on if necessary. That's always true. Obviously, it might cost a little bit more, but hey, you're getting a little more flexible, LLC to start. It'll cost a lot less to start, and you'll be able to bootstrap it. And then maybe once you've gotten it fully bootstrapped and you've got enough money to be able to make the decision to convert it, you can go ahead and do that. I don't see any problem with that. As far as taking investment from one type of company to another, if you can take investment in an LLC, the same way you can take investment in a corporation. Some people just prefer the structure because the structure allows them to control the entity in different ways. That said, most of the issues related to control can be solved by agreement. If it's an LLC, an operating agreement. If it's a corporation, a number of different agreements: voting rights, investor rights, stockholders agreements, things like that. There are a whole lot of different ways in which we can govern a company and control it and manage it if you're investing in it. So do we have any questions about, state preferences on this? I know I just went through a lot of that and I was pretty quick on it, but I will tell you, that was one of the major issues that comes up a lot. People are always like, is it Texas? Is it Delaware? What do I do? And, usually when people are on the fence, the question becomes, what kind of business are you running? How profitable is it going to be? And are you going to need to raise money for it? And if that third one is true, I just tell them, just start a Delaware corporation. Okay. And even if you're starting just a tech company, just start a Delaware corporation, because if you get acquired, in my opinion, it does a better job at protecting you on acquisition. So aside from that, though, if you have any questions about that, feel free to email me. We talk about that stuff all the time, and I do love learning about the differences in the state law because it is helpful to understand. Aside from that, so I've talked a little bit about this up to this point, but here's the real focus for the remaining 25 minutes. Every week I get asked about whether it makes sense to convert an LLC into a corporation. And to some extent, it's I don't want to say it's my least favorite question, but it's not my most favorite. I know the answers to this, but the problem is every time I have the conversation, it's a lot of finding out certain information about what they're doing, seeing what level of business they have going at the moment, and looking at their organizational structure to begin with. And really, what I oftentimes see and what is very frustrating is I'll get an LLC that has just terribly drafted, operating agreements, that has conflicting information in the agreements themselves that really, doesn't do a very good job of explaining what the ownership structure is. In some cases, some people will, they'll find certain things online and they'll be told certain things about what ended up happening with their businesses. And, we end up literally telling those people, look, I know you did all of this, but we're going to have to spend a lot of time to fix it. And so it's not just that flat fee to fix it now. It's like, it's going to be several hours worth of work just to get the consent to change the documents the way they need to be changed, basically. Aside from the initial issues, though, converting an LLC into a corporation is rather straightforward. So I would say, like I said, I already went over the overview, so I'm going to skip this. I think we've already heard enough. So aside from that, though, like I said, raising capital. If you're raising VC in large amounts, some VCs are going to demand that you be a corporation. And in some cases, they don't care what state, but in some cases they do. They'll say, you can't be a member of our cohort for our accelerator if you're not a Delaware corporation. You can't be a member of our studio if you're not a Delaware corporation. And then other considerations too, by the way. This came up actually last week. If your LLC is taxed as an S corporation and you're trying to take money from foreign investors, your LLC cannot take money from foreign investors. It is strictly prohibited under the IRS rules, under the Internal Revenue Code. S corporations can only be owned by U.S. citizens and U.S. domestic entities if they qualify for the Q subsidiary rules. And so as far as being an S corporation, the recommendation really turns into, if you are taxed as an S corporation right now, you need to go get advice of a CPA and ask them, if I convert into a corporation, is it better if I keep the S corp election, or should I unwind the S corp election and be, default taxed as a corporation? That said, that's really all that's really what you do need to ask yourself if you are going to be doing this as an LLC taxed as an S corporation. It is so hazardous. You will unintentionally bust the election if you take money from a foreign investor. If you make this decision without thinking it through at first, without considering the effects of unwinding that election, you will potentially pay a lot of money to the IRS in penalties and back taxes. Okay. Aside from that, looking for greater protection, it makes sense if you are looking for greater protection. LLCs do a good job of protecting people. Corporations generally do a better job. The reason has to do with, the org structures. Usually, corporations aren't run by just one individual. They usually have officers. They usually have people who have responsibility in other ways. And so it's not the CEO who's making literally every decision all the time. Whereas in some cases, single member, manager managed, the one individual making, the decision, single member managed, the one individual making all of those decisions is indeed just the only member. And so if that person commits fraud, it's going to be fairly easy for a court to say, we're going to allow these plaintiffs to pierce the corporate veil on you. Aside from that, the other downside, LLCs are just operated relatively loosely, I should say, with little corporate formality when compared to corporations, and corporations are just required to adhere to way more corporate formalities. Delaware corporations require that, the corporation hold an annual meeting effectively. They don't necessarily require bylaws, but they say, if you have bylaws, technically here are the default provisions you can't waive with bylaws. Here are the ones you can, right? And, bylaws need to be adhered to as well. Stockholders agreements need to be adhered to. Voting agreements need to be adhered to. Aside from this, looking to take a backseat to day-to-day operations. If you're looking to just go, if you're an initial founder and you just want to put yourself on the board and, put another person as a CEO, you can do that with a corporation really easily by just literally hiring a CEO, paying that person a salary, and then having a resolution drafted up that says, I'm electing myself as the only board member and the chairperson. This person is going to be CEO and have these responsibilities, right? LLCs can do that too, right? LLCs can have CEOs all day long. There's no limitation on that, but the LLCs have managers. And in some cases, they have boards of managers effectively. And so you can do that as well. It's very similar, but you just have to look at, what are the differences between the different structure. Do I want to do that as an LLC where it's just membership interest, or do I want to do that as a corporation where I'm, establishing 10 million shares that are authorized, but, issuing 6 million to myself and then 4 million is saved for investment later, right? You can do that with an LLC as well, but, it's generally, understood that corporations are the ones that do that. Aside from that, the process of conversion. This is basically a bullet point of every document that gets created whenever we do a conversion. So first and foremost, you got to draft a plan of conversion. The plan of conversion itself contains the previous equity structure as well as the post-conversion equity structure. It is vital that, it is vital for reasons related to minority shareholder oppression that you obtain the proper consents for doing this sort of thing. Okay. Unfortunately, when it comes to obtaining consent, a lot of people don't do that. And then, a lot of times we see that, either the operating agreement hasn't actually been executed, or it has, and it's got some terrible stuff in it, like supermajority language that requires like 9 out of 10 votes, basically to make an election to convert. We usually say, stick with majority unless you need a supermajority. We had an instance the other day where we needed a supermajority, so we put that into the contract. Aside from that, file the Texas certificate of conversion, file the Delaware certificate of conversion and articles of incorporation. Those two documents need to be filed at the same time, preferably on the same day that the plan of conversion is signed. But you can wait until like a day after to do it. But really, they need to be filed on the same day. Okay. Sometimes they don't get filed on the same day. It's not a huge deal. The only thing to remember, you have an existing LLC. That thing is going to have a tax ID number. If you're converting it into a corporation, that corporation is going to have a new tax ID number different from the old one. You do not just get to, tell your banker, hey, change the name on this thing, change the EIN. They literally have to create new bank accounts, which for an existing business can be a terrible problem. To give you an idea, our law firm, for reasons related to the fact that we're growing, is about to convert into a professional corporation. And I'm just thinking of what a nightmare it's going to be to have to switch all my merchant stuff over to new bank accounts and have to set all that up again. It's just, I simply don't want to do it, but I know I'm going to have to. And so you've got to get okay with that. And I'll tell you, I'll get okay with it, but the problem is I'm not going to like any bit of it because setting up bank accounts is a pain to begin with. So, and that's one of the real downsides. If you have a really complex, if you have a really complex bank account, set up, or you have a really complex payment set up at the moment, you're potentially just going to need to, figure out, before you go officially convert everything over, what exactly the process, step by step, it is going to take in order to get, and how much time it's going to take in order to get your business, back to earning 100% at the level it was before. Because there is going to be a little bit of lead time, I'll tell you. Aside from that, you're going to need bylaws for the corporation. You're going to need stockholders agreement if necessary, not always essential. Sometimes you need restricted stock purchase agreements if you have vesting agreements that are unit vesting agreements, and you'll just need those to carry over. And then IP assignment agreements are going to be necessary if you didn't already do those before. If not, if you did do those before, not really a big deal. We don't necessarily need those documents in order to keep doing this. Because if they existed at the LLC level before and they were indeed, technically it doesn't matter if they were assignable because the conversion is not a true assignment of anything. It's really just a reorganization of the corporate structure. Like you wouldn't need a new IP assignment agreement in that situation. And then last but not least, resolutions, adopting the initial corporate actions and conversion actions taken. That in a nutshell is how this thing goes. And to be honest with you, it can take longer than you think. A lot of times, what I have found is that it takes about, 2 to 4 weeks. If the people that we are doing it for are really business savvy and pretty sophisticated and have done a corporation before, then, this is really easy. It should only take 2-3 weeks maximum. It sometimes takes closer to a month, but only because, I'm having to sit down and basically explain the significance of all of this to them and tell people how this is about to go and basically tell them, this is how you have to do this. This is what you need to do and when. And basically, it's almost like I have to coach them on the instruction manual for how to run their business again after the conversion, because they just don't, if you don't steer people into what they need to do, they won't do it. They'll just keep operating under the LLC bank accounts, which is not what you want to do, right? Major pitfalls. This is really important, by the way. I mean, if you're considering converting, you need to listen up because this is really important. Do not convert it yet. If your LLC is currently taxed as an S corporation, you need to seek out the advice of a CPA or an accountant who can advise you, potentially even render a letter opinion on this sort of thing, and say, here is what we believe the effect of the conversion will be. As attorneys who do this stuff, I don't necessarily do tax law or do a ton of tax advice. I do a very limited amount of that, and it's only so much as I need to do in order to get a deal done, right? And really, I don't advise very much on the effect of a conversion on the S corp election because it varies from conversion to conversion. Okay. That said, just be aware that you could invalidate the election upon conversion if you don't do certain things within a certain period of time. So just filing to elect the S corp election within 60 days of creating the new corporation, if you're planning on keeping the existing, tax election intact, that is vital to ensuring that you keep it live. The other thing is any stockholders agreement needs to be drafted so that it doesn't violate the company agreement itself, or so that it doesn't violate the stockholders agreement needs to be drafted so that it doesn't violate the S corp election in any way, which I have seen operating agreements and stockholders agreements which did. The one thing some people don't know is you can't have multiple classes of membership interest or multiple classes of shares if the entity is taxed as an S corporation. You can, however, vary voting rights in an S corporation, which is slightly different. It's almost like creating a different class of shares, but you're basically calling somebody specifically out and saying, this person does not have this right in the agreement. Aside from that, if you don't have if you don't have the votes to convert the LLC into a corporation, you got to ask yourself, what does the LLC operating agreement require? Has that agreement been signed? If it has not been signed, you must look to the statute to figure out, how many votes do I need? Usually to do a conversion like this, you need unanimous if it hasn't been signed. If it has been signed, then you really just need whatever it says, which is, in most cases, I would say a majority, if not a super majority. So how many votes do you need to approve such an action? Like I said, majority, super majority, whatever it says, basically. If you don't have the votes to convert it, if you hold a vote for it and people say, no, we're not doing it, you can't go and do it, just because you think it's a good idea. That's a violation of your fiduciary duty as a manager. It's cause for removal in a lot of cases. let's say, you don't intend to keep the same ownership amounts for each individual or can't obtain their consent for the new ownership structure. We call changing the ownership structure upon conversion a recapitalization. We did a recapitalization the other day. And really, when you do a recapitalization, in the interest, you really want to get, consent to do so. That said, if you're recapitalizing something, so let's say, for example, that you're running the calculations on it, and you've got two classes of shares, but you really want to recapitalize the company and bring it to one class of shares. Effectively, then, what needs to happen is, these people need to be put on the same ownership level that they were before, as well as the people who are given more preferential rights. Basically, those rights either need to be honored in the next agreement in a certain way, or you need to make everyone equal and have those people consent to it effectively. That said, a lot of times most people will agree to a recapitalization, especially for an early stage company, because they want it to work. They want to have ownership in something like that. And why wouldn't you? If you're standing there as a roadblock to the recapitalization, you should be asking yourself, do I really want this thing to succeed? Some people will block it just because they're shrewd individuals, but I think it would be, in some cases wrong not to. That said, don't convert it yet if you are not prepared to honor the corporate formalities required of corporations as opposed to LLCs. This is pretty important. If you're comfortable with running an LLC and you like running an LLC and you don't want to run a stricter business, if you don't want to hold annual meetings, if you don't want to hold, potentially even monthly board meetings, if you have a board, and have to be subject to the consent of other people, you need to think about whether or not this is good for you. Because the end result, if you are the CEO or some C-level executive or on the board of directors, you could draw a claim of willful misconduct or a violation of fiduciary duty if you don't honor corporate formalities. That's a problem, right? We want you to abide by these rules, but some people don't. And I will tell you, a lot of people, they are, operating their startup pretty loose and fast. They're moving really quickly, not getting all the consents required, not having all the meetings they need to in order to actually, constitute, a meeting of, the shareholders or a meeting of the board or anything like that. It's important sometimes to slow things down just a little bit to make sure you're in compliance, because I will tell you, we have seen it happen. It happened actually the other day with a rather popular startup here in North Texas that, I was talking to the CEO and he was like, before today, nobody cared about, doing all this sort of, legal stuff. Now everybody's like, you didn't do this, you didn't do this, you didn't do this. And it's kind of like the pot calling the kettle black. They're literally blaming, like C-level executives of a company for behavior that the board was actually engaging in as well, willfully. And so, it's basically that meme of Spider-Man pointing at other people dressed as Spider-Man. So effectively, recommendations here before converting. Talk to your startup or business lawyer. I really encourage you to do this. It really makes way more sense to talk to these people, early on. Get a CPA's advice on the tax implications. This is pretty helpful if you have that S corp problem. It's also pretty helpful to know, what's my tax burden going to be, based on the current level of money we're making and current profit level, and based on what I'm paying my employees. Is it going to change? Is it going to be higher or lower? For some people, if they're taxed as a partnership as an LLC and they're converting into a corporation that's taxed as a corporation, they might actually be saving a little bit of money in some cases. And if you're carrying on the S corp election and keeping it, you might still be creating those tax savings that the S corporation election is meant to create. Aside from that, obtain consent from all other members of the plan on the plan of conversion, or whatever amount of members of your LLC is required to convert. And then double check everything and potentially clean up the operating agreement prior to the conversion. If you can get everybody to agree on what they own and how much and the voting rights and everything before, we go do a plan of conversion. That really does help a lot because it makes doing the conversion rather straightforward. After converting, so make sure you collect all documents and send to your CPA, accountant. We basically send a digital formation binder once we're done signing all documents. It has every single document. It's even bookmarked by us, where you can literally open up the bookmarks in PDF and navigate by bookmark. That's really helpful, especially for people like your CPA who are going to be looking at, documents that state, vesting and have 83B elections, which, are required to be filed within 30 days. And you would have to pay the initial tax on those things early on. And then aside from that, you want to maintain clear and organized records of your newly converted entity to ensure that you can produce them when asked by the IRS, lawyers, etc. This is really important. Just get Dropbox, for God's sake. Get a paid version of a document management system. Pay for it. It's worth the money because and be organized with it. If you have resolutions, don't let it be disorganized and don't lose it. Because you'd be surprised whenever I'm talking to somebody and they're sitting there asking me like, oh gosh, I don't even know where my operating agreement is. I'm like, what are you talking about? You're talking about like, did you think when you started your business that you wanted it to be worth $10 million, someday? Like, did you not think that would be a very important agreement? I just think it's so weird that, people will start businesses and think that is not as important as it really is, right? It's evidence of what you own. So make sure that you keep, that stuff in a safe place. Keep a backup of it. Make sure your lawyer keeps a backup of it. Make sure your accountant keeps a backup of it. And then, aside from that, keep up to date with annual meetings, board resolutions, stockholder resolutions, etc. It's important to make sure you're honoring the corporate formalities. It's important to make sure that you are doing anything and everything that you can to comply with the law. That said, I would say, when does it make sense to do resolutions for certain things? If you're buying property, like real estate for your business, then yeah, have a resolution for the acquisition and financing of that real estate. If you're, hiring a C-level executive and drafting up an executive employment agreement, have a resolution for that, because that's important. You're basically getting consent from either, the stockholders or the board to do that sort of thing. Hold a regular meeting of the stockholders, do it quarterly, do it annually, do it biannually, whatever makes sense for your business, but it needs to be once a year. Keep them invested. Keep them invested, not just from a money standpoint, but from an information standpoint. Implement certain processes and systems related to telling people about the information that they can expect from the company, on key performance indicators and earnings and things like that. And so I would say in general, just make sure that you are focusing as much as possible on running your business the right way. Because I will tell you, a business that is run the right way, a business that has a clear paper trail is worth far more than a business that does not. That's not to say that a business that doesn't have a clear paper trail is worth a lot less. But the truth is, if I have the entire historical body of documents, of this entire entity from the day it started to the day I bought it, either as an investor or as somebody acquiring it, that goes a long way. It makes me feel really good as an owner of that business. And it should make you feel really good because truth is, you've got everything for that company, right? So aside from that, we're at the end of our time. And so I guess, is there anyone who's still here that has any questions related to what we talked about? Any follow-ups, anything I didn't go over that you'd like to hear? So if not, my email's right there, Kyle@JonesKertz.com. Feel free to email me. Feel free to give us a shout and let us know how we did. And if I did get something wrong, or if I misspoke on something and you caught it, let me know as well so that I can correct it. But aside from that, thank you for coming. We will be hosting another one of these next month, first Tuesday of the month, I believe. I don't think we've rescheduled it for another day or anything like that. I think we will be rescheduling it in October, just because there's some stuff going on in Austin that needs to be, that we have to just, move it a week over. But aside from that, I really enjoy you guys being here. I really enjoy that a ton of people usually come and listen to this thing. And I will see you next month. Thank you very much. Bye.